Hi everyone, it's Kerry Fink with Campbell & Brannan, our in-town office. I'm here to tell you about the top few 2026 mid-year GAR changes. Luckily, there were no major changes. There's nothing that substantial. A few formatting things and a few timeline changes. So the first change we're going to talk about is actually the brokerage agreement. In the brokerage agreement, the statute of limitations was broken out to its own section. The context itself didn't change, but it's kind of more readily available. You can kind of see it more clearly now that it's broken out. The authorization to show unlisted property, they actually expanded the language, the limit of the broker's liability, and it now is more closely aligned with that brokerage agreement itself. So if you can remember, the limits the action that it must be brought within 1 year from the date of any claim or any cause of action arises. So a few changes related to the purchase and sale agreement itself, the F201. Under the section B1, on B1A, the warranties, so where buyers are taking the property subject to zoning and general utilities, they've added a little provision in there now that says that the buyer is taking the property subject to any subdivision and other governmental laws and regulations. Now, this has always been the case, right? Like the buyer is taking the property subject to whatever laws or regulations of the municipality and the subdivision, but it's just broken out more clearly now that that is something the buyer is accepting with the property. Under B4A, so still in the purchase and sale agreement, but under B4A, the right to unilaterally extend the closing, again, no context changes, but it did subdivide where it now kind of in a reformatting, it shows what the buyers and the sellers' rights. So they're broken out to be more clearly distinguished, but no context changes there, just reformatting. One substantial change, actually, on the purchase and sale is related to the holder of earnest money, section B6. So specifically, it is about when the timeline for seller to terminate begins if buyer doesn't provide the earnest money. So buyer is under contract. They say that they're going to provide earnest money to the holder. They don't. The holder then has 3 days, or the holder then says, buyer, you have to give your earnest money. The buyer then has 3 days to cure. After the 3 days that buyer has to cure, seller then has 7 days to determine whether they want to terminate or not. And that's still the case. But what is now clarified is when those 7 days start for the seller to decide whether they want to terminate or waive their right to terminate based off the fact that buyer didn't give the earnest money. And that timeline starts now when the seller receives notice that the buyer did not provide the earnest money. So buyer doesn't give the earnest money. The holder says, buyer, you got to give the earnest money. The buyer has 3 days. And then upon notice to the seller, hey, seller, buyer did not cure within those 3 days. That is what starts their 7-day timeline for the fact that they now can either decide to terminate or they're going to waive the right to terminate based off the fact that buyer did not provide that earnest money. So now the timeline starts upon notice to seller. One other thing in the purchase and sale agreement that changed was just clarifying that a broker can still accept notice for a client even after the agreement's terminated. So whether it's closed or the relationship terminated, it's now one of the things that survive closing, which there's 11, right? So this is number 10 now of the 11 things that survives closing, is that the brokerage can still receive notice for the client. And that's deemed as the client receiving notice itself. So even after closing, if someone sends you notice or your client notice, make sure you're passing that along because it's deemed as being received. On the F301, the seller's property disclosure, this was modified at the beginning of the year to focus less on water intrusion and flooding and more kind of internal water issues. And we've seen just a little bit more of a push for that. So it was modified to focus on sewer and septic backup rather than a flood or a flood zone. And it expanded beyond just frozen pipes to more broadly including interior water damage. So another change with the seller's property disclosure. And then finally, last but not least, the one I'll talk about today is the lead-based paint exhibit. whereas before buyers had to initial that they received the information relating to lead-based paint hazards in the housing, now the buyer is obligated to either initial that they have or have not received any records and reports pertaining to lead-based paint hazards in the building. So make sure, because we all know those fines can be crazy, make sure that your buyer is noting whether they did or did not receive the lead-based paint information. So again, nothing too substantial, a few reformatting, a few kind of making things in line with each other. That timeline for when the seller's 7-day right to terminate kind of now has an official start upon notice, and then just another initial on the lead-based paint exhibit, whether they did or did not receive. So nothing too crazy, but of course, if you ever have any questions, feel free to reach out to either myself at Campbell & Brandon in town or any of our attorneys in any of our offices. We appreciate you and we're happy to help. So thanks so much.